Hi, this is Jim Cunningham. It is true, women do live longer than men. We have a great webinar, great video. Christina Lindsay Orta is joining me to talk about all those things. If you are a woman and you think you're going to live longer than your partner, your spouse, you got to watch this great stuff. Hi, this is Jim Cunningham. I've got Christina Lindsay Orta here from Ascent Wealth Management, a certified financial planner. Today, we're going to talk about women live longer. It is a fact. Men, sorry. Women, what is it on average, Christina? 2/3 of women live longer than men or something like that.
Yes.
We're going to talk about women. Obviously, you are a woman, Christina, and you have a very different perspective than I do because I'm a man, and it's just how it is. This is a disclaimer, though. So I'm going to talk. Christina's going to talk. I'm a lawyer. Christina is a certified financial planner. This is not advice. This is basically talk. I am a partner at CunninghamLegal, 25 years of experience, 25 years plus. And when you get to 25, it's like, I think that's enough. We have offices throughout California. We do help clients in other states, Missouri, Texas, Virginia, and the District of Columbia. I'm a broker, but don't sell anything, real estate broker, and a certified specialist in estate planning, trust and probate law, as well as in securities and insurance licensed, and a pilot. These are the attorneys at our firm. We have another attorney here starting in a couple of weeks, and a great group of people. So, you know, if you call in and you need some help, you're probably going to end up working with one of these people. And this is Christina and the principals at Ascent Wealth Management. We've got Christina Lindsay, Alyssa Kroger, who happens to be Christina's sister, John Lindsay, who is Christina's father, and Shannon, who is the only non-relative, right? Principal at Ascent Wealth Management. Go ahead and subscribe to our YouTube page. If you're watching this live, this is going to be on YouTube later. But if you're watching this on YouTube, please hit the subscribe button, and then our stuff pops up in your feed. And we do live YouTube from time to time. If you're in California, we have offices in California. If you are not in California, we can still help you out because we are licensed in other jurisdictions. Even if we're not licensed in your state, we can still help you out because lawyers can associate in other attorneys. So we do have clients in Northern and Southern California. But Christina, you know, I'll turn it over here to you. And really the question, you know, and if you have, by the way, if you have questions, we do respond to these live, and we're doing this live. If you have a question, put it in the comments on YouTube, and we do pay attention to those and we'll respond. But maybe cover some of the basics and common mistakes. And what we're really highlighting here is if you're a woman and, you know, you're probably going to outlive your significant other, generally speaking. And if, and so this is stuff to think about, right? Or one of you is going to outlive the other one. And I think maybe that this has been sort of teed up as estate planning for women, but it also might be estate planning for surviving spouses and surviving domestic partners. So very similar kind of vein. But Christina, I will turn it over to you, and maybe you can touch on some of these common mistakes.
Yeah, absolutely. Thanks, Jim. You know, it is common that women outlive men, and people are living longer. And you know, I think I heard the statistic that women will control something like 60% of the wealth in the next decade. And so one of the common things that gets overlooked when there is a death is making sure that everything is properly titled, as well as beneficiaries are taken care of. Making sure that all the retirement accounts and insurance policies get updated to list the spouse as the primary beneficiary. I can't tell you how often we see a beneficiary or a spouse that's recently widowed and is not our existing client, that we get referred, they get referred to us, and we sit down with them, and the advisor had named, you know, the trust as the beneficiary. And that creates all kinds of complexities and, you know, issues when you're dealing with tax planning. So making sure that the beneficiaries get updated. You know, when you're dealing with blended families, if there is someone other than the spouse named as the beneficiary, and especially in the state of California, having a spousal waiver is important. And you know, sometimes there's earmarked assets. There, I was just meeting with a widow earlier today, and it was a blended marriage, and there were certain accounts that were in the trust that are titled in the trust the same exact way as their other accounts. There's no two separate trusts. It's all the same trust. However, there was a mutual understanding that this one account is supposed to go to his kids, and the other accounts are supposed to go to her kids should something happen. Well, if that's not all spelled out in the trust, it could potentially cause issues down the road. And so,
yeah, I mean, Christine, I think what you're talking about, this is really so important. So if you're watching this and you're like, retirement account, what are they talking about? IRA, 401k, 403b, TSA, those type of accounts. Now, under law, 401k, the spouse is the beneficiary unless the spouse agrees not to be the beneficiary. That is not the case with IRAs and IRA. So if you separate from your company and you have a 401k and you roll that over to an IRA, this is really important. Please pay attention to this because we have had disaster cases walk into our office. A spouse can name anyone they want on that IRA. So if you're married, you don't automatically inherit an IRA. That is different than a 401k. Now, typically on a 401k, when you try and name a trust, you hit this statutory obstacle or this speed bump because it's not the spouse. So it tends not to, I would just say in practice, it tends not to be as frequent as the IRA. And here's the thing, Christina, you and I were talking about this yesterday. The quality of professional services, just because someone has a designation or a license does not make them competent. Okay. I'm going to kind of pull the curtain back and tell you the truth. There are a lot of people walking around there who frankly do not have sufficient training. And this is true for lawyers. It's true for financial advisors, even CPAs sometimes. Now they tend to be, a little bit more with it when it comes to taxes. But if you name your living trust as a beneficiary of your IRA, that is potentially a really big problem, especially if you're married, because Christina, unless you do some tricky stuff, you're precluded from rolling that IRA over. And you've got some really weird time periods in there. So really important, a lot of our clients, Christina, they've got a lot of money in IRAs. And if you're sitting there and you're like, yeah, Jim and Christina, you're right, I have a lot of money in my IRA. You really need to pay attention to who the beneficiary is because that beneficiary gets everything. So if your spouse is going to leave you an IRA, or you think your spouse is going to leave you an IRA, you better double check that beneficiary designation because we've seen it where the spouse is not the beneficiary. I mean, the trust being a beneficiary is a problem because you can't roll it over. A trust, it all pays out. There's some lawyers out there who say, well, Jim, yeah, if you do this and you do that, and if you have all this stuff loaded up in your trust and other processes, it'll work. But I'm telling you, in the real world, it's kind of like they talk about the fog of war. When somebody gets sick, when somebody passes away, a lot of stuff can change between the time when you set it up and when you actually need it. And those can be inadvertent changes. So super important. I think people do not talk enough about who the beneficiary is on retirement accounts, but I promise I'll turn it back over to you. To help myself. I'm just talking.
That's okay. Yeah, no, it really does depend on who the advisor is, who the custodian is, because ultimately there has to be a custodian wherever your account is custodied, whether that be TD Ameritrade, Schwab, Fidelity. It's going to depend on what their rules, how their estate planning team interprets things. If you're trying to bypass the trust, if the trust is named the beneficiary, there are all these if then that situations where, because an IRA is a beneficiary designated asset. So you may have a trust that owns all of your non-retirement assets. It's important to make sure that trust is funded and in your, another thing that often gets, while I'm speaking about trust for a moment, another thing that gets overlooked is the trust is often can be either spouse's husband passes away and the social was the one associated with that trust account. You have to then either get a new trust account opened or switch the social registration on that account so that it's now the surviving spouse's social that then gets associated with that account. Sometimes that isn't done during the trust administration process. But I want to talk about this settling the qualified accounts quickly comment here for just a moment, because trust administrations, as you know, Jim, sometimes it can take 6 months, sometimes less, sometimes more, oftentimes more to settle a trust or settle an estate and make sure that you're avoiding probate. The things that don't take time are anything that is beneficiary designated. So a life insurance policy, a IRA or 401k, something that is a named beneficiary can be handled quickly. And I know that there's a grieving process whenever there's a death of a spouse, but there is a sense of urgency to get those handled quickly. We had a case where, unfortunately, husband and wife both died within 30 days of each other. And they did not have contingent beneficiaries on their IRAs. And so they were each other's beneficiary with they had 2 daughters. No one was named as the contingent beneficiary. That asset got tied up in probate. And RMDs were missed, and there was penalties for taxes, and it took a very long time to settle that estate. So even in the grieving process, the things that are beneficiary designated are the things that you have to address first and foremost.
Yeah. And we have up here, do not name a trust as beneficiary of an IRA. What we mean is, generally speaking, do not name a living trust as the beneficiary.
Revocable trust.
A revocable trust. But there is a special IRA legacy trust. So if you're watching this and you're like, well, Jim, I did a trust with you, and we have named our IRA, the IRA beneficiary is the trust. That is a very specific purpose-built irrevocable trust, separate from your living trust. So just for clarity's sake, if you've done estate planning, or you've talked to us or somebody at our firm, and we recommended doing an irrevocable trust for your IRA, there is special language in those trusts. So what we're talking about here is your living trust. So that real disaster. And Christina, to your point about beneficiary designation, there's a flip side, kind of a darker side. We'll take it a little darker because the lawyer's talking. If you have all of your money locked up, if you have somebody you're going to leave your assets to, maybe an irresponsible beneficiary, or somebody who you're worried once that person inherits, the spouse is going to divorce your kid or whomever you're leaving your money to. If you leave, it takes 6 months, 10 months, 12, 50, it just depends, right? Because these trust administrations, they just inherently take a long time. We have a lot of content on our YouTube page about that, about why it takes so long. But the IRAs, you just get a death certificate, you go in and can get the money. So it's really important. If you have somebody, maybe you have a loved one with special needs, you've got someone who is irresponsible with money, or you're worried they're going to blow it, or someone's going to take advantage of them, or they're going to lose it, doing this IRA legacy trust, this IRA inheritance trust, this IRA legacy trust that we call it, puts a wrapper around the money, because otherwise the beneficiary walks in with a photo ID, your death certificate, and they get the money. Now, if you have an IRA, you have $1 million IRA, and those all pre-tax contributions, that $1 million, when it gets paid to the beneficiary, is taxable as income, right? So when that person inherits that million, that is taxable as income. And the problem is there is not sufficient withholding, because in California, you're going to be up over 50% in income tax. And so what happens is you get 900,000 and you leave 100,000 at the institution, you go out and blow the 900,000, you're going to end up with a $500,000 tax bill. And that's where you get into the tax hole, for lack of a better term. So it's very important, if you have a large IRA and you're worried about your beneficiaries, please look into this IRA legacy trust.
Yep. And the other thing I'll mention on here, just some common mistakes, is to not use work emails for financial accounts, because it's a common mistake. We all check our work email probably way more than our personal email if you're still working. But we also have dealt with a recent widow where, all of her late husband's emails were going to his work email. Any of the password recoveries, the password resets, documents that she couldn't get her hands on. And then you have to get an employer and HR involved. And it's more difficult if you don't have communication for financial statements, assets, anything that you would need to access if there was a passing, making sure that you can get access to those through a shared email or something that you would have a password to. So that's very important to make sure that that's taken care of.
That's actually kind of a great topic for a webinar, is like email, because I got to tell you, email drives me nuts. But if you are working somewhere, something you understand, when you separate from that company, you're not going to have access to that email. So it's really important that you have a separate personal email. And we could talk all day about whether you should use a free email service or not and what they look at. But very, very important that you think about getting a separate email. The other thing too is, a lot of people now have two-factor authentication, which is where something, it's like facial recognition or some other type of inner functionality with the cell phone. If your spouse passes away and you don't have those access codes, it's a real problem. Okay, so this is sort of basic stuff. Is you want to be able to open up your spouse's or registered domestic partner, your spouse's phone. So,
Correct.
yeah, great stuff. If you guys have any questions, put it in the Q&A. We do have a question right now. Anonymous. I love, Anonymous is probably the most frequent person who asks a question. Anonymous asks, is tax payable less with beneficiary as an IRA legacy trust compared to the beneficiary as individual when the IRA is about $1 million? Anonymous, great question. All right. So here's the long and short of it. Everyone pays federal tax, right? You're not going to get around that. Not everyone pays state income tax. In California, Christina and I are residents of California. So we have the honor and the privilege of paying tax at the highest rate, I think, except for New York City, highest state rate. And we love paying our state income tax, don't we, Christina? But Nevada doesn't have state income tax. So if you're a California resident and you leave your IRA to someone who is a Nevada resident, California is never going to collect income taxes on that money. It's just not going to happen. So what a lot of our clients do is they will say, well, Jim, that's great, but my kids live in California. What do I do? Well, what you can do is you can leave your IRA to an IRA legacy trust that is cited or located. The physical documents are still in California, but it is under the laws of Nevada and a Nevada trustee. And this is really important because if you're a California person and you're a trustee of a Nevada trust, you are subjecting that Nevada trust to California state income tax on undistributed income. Okay, just roll with me on that. If you don't get it, just understand the fact that you're a trustee subjects that trust potentially to income tax. Well, the flip is true. So let's say you have this $1 million IRA, you leave the IRA to an irrevocable trust in Nevada with a Nevada trustee. When those minimum distributions come out, they stay in the trust. So then this is a little bit hard to get your head around. You have this IRA bucket and the trust is the owner effectively of that IRA after you die, not while you're living, but after you die. And the money stays in the trust bucket, even though there's a smaller pot of money in the IRA bucket. So that money, as long as that stays in the trust, no state income tax is payable. If that income is distributed to a California resident, when it is distributed to a California resident, the individual Californian, he's got to pay income tax on that. That's the current law. Now, we think that law may change. So there are a lot of cases going through the courts right now where that concept may change. There are a lot of reasons why you would argue yes and no, but just understand it is a tax deferral strategy. So on the example of $1 million under the Secure Act, all that money comes out after 10 years. Well, let's say it's gone from $1 million to $2 million because it's invested with Christina. It does well. There's no promise there's no guarantee of a return. But if that money goes from $1 million to $2 million, you've got over a $200,000 state income tax bill. Well, what you can do with that is you can defer that $200,000 bill if that money stays in that trust. That gives enough time for the beneficiary to become a resident of Nevada, or I don't know, go to France for a year or whatever. I don't know, go somewhere. But it allows you to not be a California resident, so you can take that money out and bypass that $200,000 tax bill. So I know kind of a long answer to a short question, but it's a very compelling planning proposition if you have a larger IRA.
Yeah. And I would say that with, doing all kinds of planning surrounding the beneficiaries, that's important because also if you do have a blended marriage, and you've named the spouse, the beneficiary with the intent, let's just say to once that surviving spouse passes to have the money go to both, the shared marriage children or the children from two different marriages. Once that spouse owns that IRA, they can change it. They can change it to their new future spouse. So there also should be some planning discussions as to how to make sure that, the surviving spouse makes sure that that asset goes to the intended end beneficiary when both spouses have passed. So you definitely have to consider where you want the asset to go, the taxation, as Jim was mentioning, the income that will eventually be taxable to the underlying beneficiary. It could be the children, it could be the grandchildren, and what tax bracket are they in? There's charitable strategies we can do with it. So we definitely want to make sure that what the plan is for those assets has been planned for, both prior to passing and post death. Now, when we're dealing with life expectancy, it is a reality that people are living longer. And so people are living longer. On average, women outlive men. That's just a fact. But planning for longevity, when we are doing our retirement plans for our clients, we take the youngest spouse out to age 95. We plan for longevity. We plan for inflation. And because there's a near 50%, 44% chance that a married couple, that one will live beyond 95, or at least to age 95. There's a 44% chance that one person will live to 95. So planning for longevity is key. And then the costs that go with that are also something to plan for. And Jim, you're on the control of the slides here.
So well, there's a follow-up question to our question. Is Anonymous asks, again, thank you. Is this only when the beneficiary is outside the same state as the trustee? Is the tax rate for the IRA Legacy Trust higher than the individual tax rate? The answer is yes. And so what you have, so the question here is, yes, trust rates are higher, but what you have levers, you can distribute some income. So it's not like an all or nothing. It's not binary. It's all the income. You let a little bit go out and you're doing tax bracket arbitrage. So you're doing a little bit of planning and you're using advisors. And, we met yesterday. One of the things we do is family office in our law firm, and a multifamily office. What that means is basically we're kind of in charge of the A team that monitors all this stuff. And we had a meeting, a fantastic meeting yesterday with some clients, great clients. And we went through a lot of complex things. This is one of the things we talk about. How long are you going to live? What are your asset structures? How many LLCs do you have? What's the structure of your property? When are you bringing the kids into the business? All these things. It's really good to have a team of people to really help you with this. And I will tell you, Christina, 95%, 99% of lawyers and financial advisors don't do this with their clients. I mean, it's really nuts. And I think this is something that many, many people, and if you're watching this, this is something you might benefit from. So the season for family office is coming up. It's typically the first quarter of the year. So that's just a few months from now. But this is really, I got to tell you something, my father-in-law turned 90, Christina, and I never thought he'd live that long. He kind of wore himself out working, but through the miracle of modern medicine, here he is, 90, having a great time.
Yeah, we have a handful of clients that have lived to 100. So, it's not uncommon. And one of the things that's important to think about, I'd say that of the few tax benefits, because there's not many in California that exist, is that we don't have a state inheritance tax, but some states do. And as clients seek tax-friendly states in retirement, it's also important to think about the state inheritance tax. So because the federal exemptions are so high, over, 12.6 million now per person, Jim, 12.2.
12,060,000. That's correct.
Yeah. So you've got a very high federal exemption before there's going to be any estate tax assessed. However, you've got states like Washington, Oregon that are very tax friendly if you live there in retirement, but not tax friendly if you die. So especially when there's a passing of that first spouse, and if you do have a surviving spouse where now you are bumping up against those state estate tax brackets, it's something to plan for. Should you be gifting assets? Should you be, gifting to the next generation, or moving? You want to have those discussions. It should at least be a discussion.
And here's another reason to have an A team. And we've talked about this in the past. If you watched our webinars, we had a client years ago who opened a bank account in a state chartered bank. Now, I didn't know the difference between a state chartered bank or a federally chartered institution. If you put money in a state chartered bank in Oregon and you live in California, that's probably going to be included in your estate for Oregon inheritance tax purposes. Also, if you have a bunch of assets in Oregon and you say, well, I don't want to, because Oregon's got $1 million exemption and it's 16%, right? Up to 16% on amounts over $1 million. That's a lot of money. If you say, well, I live in Oregon, I got all these assets in Oregon, I'll just move down to California and die in California. Doesn't work that way. If those assets are cited in Oregon, they're subject to death taxes in Oregon. So, and every state's different. Okay. We have 50 states. We got 50 experiments running simultaneously, plus Puerto Rico. I guess you can throw those guys in there. You know, we've every state's different, and you really have to pay attention to this. So a lot of clients, that's one reason people use LLCs. So if you own like a commercial property, if you're a California resident and you own a commercial property in Oregon, if you don't put that in an LLC and you die, it's subject to Oregon death tax. If you put that business asset, not personal use asset, doesn't work for homes, business asset into an LLC, it is not subject to Oregon inheritance tax. So very, very important. So if you own property in other states, you really need to seek out lawyers and financial advisors and CPAs who know what they're doing. Anonymous asks, is the beneficiary for a term cash value life insurance to be life insurance trust or individual? So question here is, I'll let you take who the beneficiary should be for life insurance, or, you know, some people say make it the trust, some people say make it individuals. I'll let you cover that. What is a life insurance trust? A life insurance trust is designed to own a policy. So a life insurance trust does not receive the death benefit of a policy that you own. The life insurance trust owns that policy. You're not going to be the trustee of that trust. Someone else has to be the trustee. And the premiums that you contribute when you pass away stay out of your estate. And that life insurance trust, free of income tax, free of death tax, that's a really big deal. And a lot of times it provides liquidity in an estate to actually pay the taxes and not have to sell assets. Christina, what are your thoughts on leaving the life insurance to a living trust versus a spouse and kids? What are your thoughts on that?
You know, it really depends on the client, the dynamics of the family. Is it children that would be involved? You know, knowing that it is beneficiary designated, and trusts can be complex. Trusts can take time to administer and settle a trust. If there's any contesting of the trust from underlying beneficiaries. Whereas if you name an individual outright, it can be distributed and not wait for the trust administration. But that doesn't always mean that that's the right answer. It depends on the family dynamics. So
I'm a pilot. I would say if you're a pilot, you're always responsible for your own negligence. If you leave life insurance to your living trust, it's part of your estate. If you do not leave it to your living trust, it's not part of your estate. I think again, this is case by case. You're sort of looking at this on an individual basis. I'll tell you what, if you meet with a lawyer for 20 minutes and they set up an estate plan for you, find another lawyer, because it takes way longer than 20 minutes. Otherwise, it's people just handing you forms that really aren't custom tailored. Ron asks, I am collecting full social security benefits. Wife's social security is currently affected by GPO WEP offsets, even though she satisfied the required minimum 40 quarters. Will she be able to collect something from my social security upon my death? Do you know the answer to that, Christina?
If you're a surviving spouse and you were married for 10 years or more, you will have access to collect a surviving spouse benefit.
Yeah. And it may be, if it's lesser than what you're getting, you would just keep yours. That's my understanding. I'm not.
And we're going to talk about,
okay, we're going to talk about that. You're way more of an expert on Social Security than I am. So I just know I pay a lot in Social Security tax. All right. Anonymous asks, if the bank is federally administered, what you explained would not be relevant. I think so. And again, I'm going to tell you something. If I don't know something, I'm going to say, I don't know. But it was weird that there was a state chartered bank. And the context was because the LLC owned a state chartered bank, the LLC had to be registered in that state. And so it was a slightly different, but I think these are the nits that you have to pay attention to. And I'm telling you, I don't know anyone who knows all the answers. This is why it takes a team. It takes typically that three-legged stool, that CPA, financial advisor, and attorney. All right. So AB Trust, I'll cover this very briefly.
Yep.
This used to be what everyone did. All the cool kids did AB Trusts. So this started, I think, in 1982. And it lasted until about 2011. So it had a really good run. You know, it had a 30-year run, 29-year run. So what it used to be that I'm married. If my wife dies, she has a $12,060,000 exemption. Well, when the rules changed, it was $1 million, $5 million, whatever it was. It was a much lower amount. It used to be that she had a $600,000 exemption, meaning she could leave $600,000 tax-free. I have a $600,000 exemption. I can leave $600,000 tax-free. But if I inherit from my wife and there's no planning and I just inherit all her half of the property and now I've got everything, I only have one $600,000 coupon, one $600,000 exemption where I can pass those assets to the kids. Well, what happened under the Obama administration, and I say this to identify a time period, not politically one way or another, in 2011, during the Obama administration, that exemption went to $5 million per person. And now the spouse could inherit 5 million from the other spouse. So that was a really big deal. That was a real game changer. And frankly, for most people don't have 10 million, right? Especially in 2011. So for most people, there was no need for the AB trust. Lots of people had a $1.2 million estate, right? Or had a $700,000 estate, but not many people had, this $10 million estate. Well, in 2017, under the Trump administration, that $5 million exemption was doubled. And now it's 12,060,000 because there are inflation adjusters there. In 2026, that $12 million gets cut in half because the Trump era tax cuts, right, that were passed in 2017, those expire for the estate portion, those expire December 31 of 2025. So if you're a wealthy individual and you've got 20, 30, 40, 50 million or more in assets, or maybe even over 10 and you're single, or over 5 and you're single, what a lot of people are doing between now and the end of 2025 is they're looking to make some gifts, right? And there are artful ways of gifting where you can still retain control and sometimes you can still get some benefits. But a lot of people are doing that planning. That's what our family office helps out with our clients. So that's a multifamily office. It's on our website. I'd really encourage you to take a look at that. And Ashley's going to put a link in the notes there on the YouTube page. The other thing is that you need to understand, if you're a higher net worth individual and you're looking at this and you're going, wow, this sounds really complicated, I need to get on this. There is a massive shortage of labor, of people who know what they're doing. What I mean by that is there's a labor shortage everywhere. There's a massive labor shortage for lawyers. Not many lawyers know how to do this. Not many lawyers have been doing it for about the last 10 years. And I talk to so many lawyers with so much institutional knowledge, they're retiring, they're passing away, right? And all that's going away. There's going to be a massive traffic jam in 2025 when people say, wow, the law is going to change. So if you're a higher net worth person, I'd get on this right away. I would not wait. Find a lawyer, assemble your A team, and make it happen. So QTIP Trust is kind of interesting. QTIP Trust is an acronym. It stands for Qualified Terminable Interest Property Trust. So what this idea is, if my wife passes away and she's worried I'm going to get married 5 minutes after she passes away, which is what she tells me, she says, it took me 30 years to train you, I'm not getting remarried, right? So if she passes away and she's like, I want to make sure that my half goes to the kids, there's a trust where she can leave everything to me and I can get the benefit of that trust. There's no death taxes. So even if it was a large amount, there's no death taxes. There's only death taxes when I pass away, and she can control where the money goes in an extremely tax efficient manner. So very important to understand, you might see this in an ABC trust or an AC trust. If this is sounding familiar to you, typically the purpose of a QTIP trust fundamentally is to control the ultimate distribution. Sometimes it allows you to pick up an extra generation skipping transfer tax amount. That's totally beyond the conversation today, but it's something to know. There are several reasons why you might want to have a QTIP trust, but primarily it's to control who gets the property when that first spouse to die, right? When that first spouse passes away.
Well, the important conversation too, Jim, is that you have a financial team that can handle funding the appropriate trust, because you want certain trust. If you are going to have a taxable estate, you want certain assets to be in certain trusts. And if you don't have that care coordination, especially when there's a death of the first spouse and you do have a high value estate, you should be looking at what assets go into what trust. And if you don't have a high volume estate and it's a low estate that has an old AB trust, you should also be having the conversation is, should you terminate the B trust? And that should be an open communication between your certified financial planner and your estate planning attorney, and planning on behalf of the widow as to what does this look like in the short term and in the long term, and funding those trusts appropriately. Now, when it comes to the widow's penalty, this is something that is not spoken of very often, because it probably doesn't happen very often, although it does happen, and we do see it, where you have one of the spouses pass away prior to age 60. And so there is that period of time where, let's just say that you had a spouse that passed that was over the age of 60, that was already collecting Social Security and That income benefit has gone away. The surviving spouse cannot collect Social Security until age 60. And again, had a client met with earlier this week, and she was 57 when she was widowed, and her husband had already been collecting Social Security, also had a pension. There was a pension reduction because the pension was reduced to pay a lower benefit to her than it did to him. And so she had a reduction in her pension, less income to live on, and can't collect Social Security until after age 60. And even at that point, and we're going to talk about this in a moment, you still need to analyze whether you should collect that Social Security at 60. But there is that penalty in period of time. There's also a couple other penalties. There's a penalty in a sense that in the year of death if you're a married couple filing jointly, and in the death of that first spouse, in the year of death, you can still file married filing jointly. However, that very next year, then you're filing and you're in the single filer's tax bracket. So you can see here's an example of a client that was making $200,000. And if the surviving spouse's income is reduced to $185,000, when you compare the two tax brackets, they were in the 24% federal tax bracket, marginal tax bracket, jumping to a 32%. And because of the income as a single surviving spouse, you also have IRMA Medicare premiums that are significantly more. So on this next slide, we're going to just show a couple examples of what that means. But here's just another quick, before I talk about IRMA specifically, here's that widow's penalty and another way of looking at this. Again, if you had same amount of income, let's assume you had no reduction in income, and you lose that standard deduction of 2 people, you're going to have more taxable income and more taxes to pay, even though your income didn't change as a single filer. So this is something, again, you have to plan for and make sure that you've got something in place to help satisfy your net income needs to survive net of taxes.
Yeah, actually, and to your point, Christine, if you look at this, the tax here, it goes from 8,000 to 14,000, almost doubles, right? Just because somebody dies. And a lot of our clients, a lot of people have a lot of money in IRAs. And if you're married and you're taking that money out of an IRA, you're filing it at a lower effective tax rate. By the way, marginal tax rate is the highest tax rate you pay. If you're married, you're going to pay less tax. Let's say a husband and wife if the only asset they have, they're 75 years old each. If the only asset they have is $1 million IRA and they're taking out 100,000 a year or whatever it is, your taxes are going to double on that as a bottom line. Okay. So, and just because somebody passed away. So when you're meeting with your A team and you're trying to answer some big rock questions. Number one, am I going to outlive my money? I mean, I think that is the number one money retirement thing that people are thinking about. Am I going to run out of money? You got to talk about taxes. You got to think about taxes because you have essentially fixed expenses. And if you have less available cash to pay those expenses, it's going to change the point at which you might or might not run out of money. So very, very important slide, Christina.
Taxes and inflation. And then here's kind of a better look at the IRMA adjustment. And
now, I thought, wait a minute, wasn't IRMA a hurricane?
No, that's
a hurricane
right now, but no, I'm just, no, hopefully everyone's doing okay with the hurricanes on the East Coast, but this is an income adjustment for Medicare premiums. And so if you, again, are in that example that we used previously of 185,000 and you are married filing jointly and your Medicare Part B and D premiums were in that $238 bucket, if you're now making the same amount of income as a single filer, not only is, we showed in the previous example, you're paying 77% more in taxes, but you're also paying double in Medicare IRMA premiums. So you've got an adjustment because you're considered high income. They have an additional surtax, if you will, on Medicare. So these are things that, again, it's kind of an unfair penalty to that widow that you have to make sure that you have planned for, or what is your plan going forward if you didn't plan for it? Where do we need to make sure that we have enough income to last a lifetime to cover the increase in costs? Another increase in costs, because we talked about longevity at the beginning of the presentation, is rising healthcare costs. This is where, inflation's front and center right now, certainly at this moment in time. But even when we had low inflation, healthcare was running at about 6 to 8% a year. And so this is something that, again, what currently costs, $508 for a 65-year-old is going to cost, significantly more than double in 30 years at age.
Or what are you talking about? This is like what the portion of Medicare you have to pay, right?
Correct. Yeah.
So it's going to triple in 30 years.
Yep. And the supplemental cost of policies, it's really that supplemental cost where you're paying for what Medicare doesn't pay for and having an additional supplemental policy. Those costs are going up 6% a year.
Crazy.
So, and then long-term care, the likelihood that someone will need, the probability that someone will need long-term care of any type is, over 60%. As you can see, that the chance of that one of the spouses will need care is over a 60%, 64% probability. So, planning for that cost in California for a private room, you're looking at over $9,000. To have in-home care is still over $5,000 a month. So it's not inexpensive, and it's making sure that you've planned for that. And if you are a surviving spouse as a female with that likelihood of living longer, the question is, do you want your provider to be an adult child? When you look at the providers of unpaid healthcare, elder care for long-term care, 51% of the providers of that care are your adult children. And so oftentimes we sit down and have this conversation. Do you want to be a burden to your adult children? Do you want, the average caregiver takes about 7 years off of their life expectancy. If you've ever had to care for a spouse or a loved one with long-term care needs, it takes about 7 years off of your life expectancy being that caregiver. So there are ways that we can plan for this. We're going to actually do a long-term care awareness webinar in November, as that's long-term care awareness month. So we will certainly get into more detail on that in November.
Hey, Christina, as you're talking, I'm thinking about some recent meetings I've had with clients. And there are two things that if you're watching this, you might say two things. You might be thinking two things. Number one, I'm going to self-insure. I will tell you, I meet with a range of clients, and we met recently with some clients, very, very high net worth clients who easily could self-insure. And we talked about long-term care insurance. They're moving forward with long-term care insurance because they're insuring a risk. And the risk is I have a high probability that I'm going to have some type of physical or mental impairment before I pass away. And I want to insure it like I would, if you buy collision on your car, if you can afford to write a check to replace the car, you are still going to buy collision coverage on the car, right? Because that's a risk and you want to insure a risk. And the other thing that you might be looking at this and thinking, well, I'm not so worried about me. I'm more worried about my in-laws that I'm going to have to pay the care for, right? So if that's you, if you're the deep pocket in the family, or maybe it's your parents, but maybe it's your in-laws, right? If you happen to be the deep pocket in your family, guess what? You can buy this for them. You can write the check because guess what? You're going to write the check anyway. And Christina, maybe if you can talk briefly, I don't know if we cover this too in depth, but maybe kind of how it was done the old way and the new way, just kind of briefly.
Yeah, just as a quick, tidbit, this is something that the old way of doing life insurance, or not life insurance, sorry, long-term care insurance was, you pay as you go. It's just like an auto policy or a home policy. You pay for that homeowner's insurance policy in the case that you have a fire or in the case of destruction. But if you don't ever need to use your policy, or you're never in a car accident for your auto policy, you never actually reap any of that benefit of what you've paid in premiums back. Long-term care is actually probably a higher probability of use, that you'll have a higher probability that you'll need long-term care than you do getting in a car accident or having a fire or some sort of impairment to tap into your homeowner's insurance policy. Even though that likelihood is higher, you used to have to pay as you go, pay these premiums. And if you never needed the care, those premiums are lost. The new way of doing this is you can pay premiums either as you go, or you can pay premiums like one time, lump sum fund it, pay it up, and just say, hey, I want this bucket of $100,000 to buy long-term care. That might leverage me $200 to $300 or more $1,000 to use for long-term care in the future. And if I never need it, at least that 100 that I put in will go back to my estate. So it's the new way of doing it is not use it or lose it. There is residual benefits is typically the new way of funding long-term care. So we will talk about that more in November.
Great. I mean, that's fantastic. So many people, I got to tell you, that resonates with so many people. They're like, look, I'll just write a check for 50 grand, 100 grand. And if it's never used, you essentially get that money back plus kind of CD rates of return. Truth be told, it's a life insurance policy. The life insurance company is holding your money hostage, but that's okay because you're covered. And you can get a 2, 3, or more X multiple on that for coverage. All right, let's talk about Social Security survivorship.
Yeah, as I mentioned, there's that widow's penalty where you can't file a claim as a surviving spouse for Social Security until age 60. And so you can't file until age 60 as a widow if you were married over 10 years. But that doesn't always mean that that's the best age to file. We have to consider, are you still working? Do you still have taxable income? Could that be taxed more? Would it be beneficial to wait until 62? So here's some examples of where maybe it's better to wait till 62, take your own benefit, and then switch to the survivor's benefit at 67. There used to be a lot of options for married couples where you could start your own benefit, then or file a spousal benefit on your spouse, wait, and then take your own benefit at 70. That went away in 2015 under the Obama era. For December 31st of 2015, that went away for married couples. These options as far as how you can file your benefits for Social Security as a widow, those options didn't go away. And most advisors don't know how to properly advise on this. They just say, hey, you can take it at 60 or you can take it at 62. But again, that doesn't mean that that's the right answer. So we want to look at, because those options of, what is the best filing strategy? Do you take your own benefit? Do you take your spouse's benefit? That's something that should be analyzed. There are options available. And the other thing that often doesn't get looked at too is, if you have, a CalSTRS or CalPERS situation, there could be a windfall provision where you might not even have a Social Security benefit. So there's those little nuances that we do want to make sure that we're looking at.
Yeah. And again, this is like, you need an 18 for this. Can you figure this out on yourself? I don't know. Can you perform surgery on yourself? Yeah. I mean, who's going to do that? I mean, you really do need your A team. And we do have a question here. When the spouse at the time of death is collecting Social Security, will the surviving spouse get the full Social Security at age 60? Interesting question.
At age 60, it's typically reduced, which is, if we go back that slide, that's that example. There's going to be a reduction. And so it requires analysis. It does require getting that information from Social Security, because you can see, at age 60, if her husband, in this example, husband passed away with a full retirement benefit of $2,000. If she takes that survivor benefit at 60, it's $1,430. So no. Yeah. No, you don't get necessarily an apples for apples conversion on that. So now if you both, let's just say, married couple, both waited till full retirement age or age 70 to take Social Security, husband's benefit was $3,000 a month, wife's benefit was $2,800 a month, you're going to get the greater of the two, assuming all things equal. But oftentimes not all things are equal. So we do have to analyze that.
So if you smoke 3 packs of cigarettes a day and drink a handle of bourbon, you're probably not going to make it till 90. So you might want to think about taking it early. I mean, I'm saying this kind of jokingly, but my point is, if you think you're going to have a shorter life expectancy, I think that's highly relevant in calculating Social Security, isn't it?
Unless you have a younger spouse that will probably significantly outlive you and you have a higher benefit, then maybe you don't.
But the great thing about Social Security, it's a public benefit. It's a social benefit. And there is an answer. Okay. It's highly dependent on your age and what you put in, but there is an answer. Okay. It's a math function. All right. RMDs. RMD stands for required minimum distribution. If you are putting money into an IRA or a 401k, that is not a Roth. Okay. That is never converted to a Roth. When you hit a certain age, you must start taking money out of that account, even if you don't want to. It is based on your age. It is based on the account value as of December 31 of the prior year. And then you have to take that money out by, typically, unless it's your first year, typically you have to take it out by the following December 31. And so this is an unwelcome surprise. It is taking money from the left pocket and putting it into the right pocket and paying Uncle Sam and the governor or the state of California money if you're in California, or whatever state you might be. And these get higher the older you get, right? I mean, look at that, Christina, 90, 8.2%. If you got $1 million in a retirement account at 90, how much are you taking out? You're the math person. It's a lot.
A lot.
$2,000.
So,
yeah.
So this is where, yeah, definitely taking a look at required minimum distributions, which have been increased to age 72 under Secure Act 2.0. It's being discussed that it might increase to 75. Whatever age it ends up being, we can see that the older you get, the more you're required to take out. So it is something that needs to be analyzed as to what the best and most efficient way for taxes is to take that out. And returns do matter, and if the RMD is not taken, there's a 50% tax penalty. So when we look at returns and the sequence of returns, it certainly affects the required amount of distribution and what residual assets will remain. So, for example, if you had that 08 example down 37% on the S&P 500, you started with a balance of 815, your required distributions near 5%, the ending year value is now 473. That's a pretty big hit to your assets. And are those assets going to last? If you're living on those assets, is that enough to maintain that distribution for the rest of your life? You can see that RMD goes from $40,000 to $25,000 in the bottom example. And is that $25,000 going to be enough? Maybe you're required to take out more than you need. Maybe you need 30. And at one point you're required to take out 40, but then you're trying to take out more than you're required because you need that income to live on. So there are also ways of ensuring the income. And so you can add a layer of insurance. If we go to the next slide, it'll show here. You can insure required distributions, kind of based on some clients. If a lot of your assets are in tax deferred buckets and you need those assets to live on and meet your income needs, this is not necessarily a solution for all clients, but sometimes it makes sense to add that insurance protection, that mailbox money, rather than having your required distributions or your income be subject to market volatility. Maybe it's worth insuring a portion of your IRAs so that your income needs are consistent regardless of market conditions. So these are things that we can do too, to make sure that if there is the death of one spouse, that the surviving spouse will have enough income to meet their needs.
Yeah. And you know what, Christina, you're talking about a tool here that is for some people and it's not for other people. So if you're watching this and you go, wow, that sounds great. Or if you're watching this and you go, wow, that sounds terrible. You're both right. Okay. It just depends on your situation. But I'll tell you what, if you're the kind of person who lays awake at night and it is really stressed out, because right now in 2022, everything's gone down in value, right? Like it's just kind of, for the time being, everything's gone down in value, bonds, stocks, everything. And if that makes you completely stressed out, then you need to look at some planning strategies where you're going to relieve that stress and have some guarantees. They're not free. Okay. You give up topside potential, but you're really, if you can't sleep at night and this is really stressing you out, there is a path where you're not necessarily going to be as stressed, or maybe not even stressed at all.
And because this is a estate planning for women conversation, there was a study that just came out yesterday, and it just shows how much more emotional women are when it comes to investing. And they are much less of a risk taker than men are. And because women do outlive men, and if, the surviving spouse might not want as much volatility or risk in their portfolio, that's when these conversations are important.
Yeah. All right. So Anonymous asks, is annuities from retirement or non-retirement account? These are from a retirement account, but they could be a non-retirement account. Yeah. The only difference there is how it's taxed. Okay. Yeah. If it's from a retirement account, every dollar coming out is going to be taxed as income. If it is a non-retirement account, part of that is going to be taxed as income and part won't. So that's the difference. So we have a case study here. We got husband and wife. early 60s, no children, spouse has cancer scare. And so, this would be the husband. So planning for potential widowhood. Um, Obviously, they're going to be meeting with the estate planning attorney, making sure everything's in place. We're talking about long-term care. LTC means long-term care policy planning. What about a rider or existing life policy? You want to talk about that, Christina?
Yeah, so sometimes, a life policy has a life insurance policy can have a long-term care rider attached to it, meaning that you can tap into the death benefit that you would otherwise have if you passed away. You can tap into that tax-free during your lifetime to use that policy for providing long-term care. So oftentimes we want to look at that. Is that something that we should add more money to? Some policies, very few, but some allow you to add money to the policy without having to go through additional insurance screening. So you might have that leverage factor again, where you have arbitrage, where you have like a 3x multiple, and we know, okay, now this person's going to have a need for care for at least a period of time. We can put more money into that policy without getting reinsurance. So these are things we want to look at. We also, this is similar to a case that we've dealt with a mutual client, Jim and I. And there was a lot of planning that was done for this client, like a QPRT, a qualified personal residence trust, that it's done for the ill spouse. It's a lot of, that spouse's family's money that was planned for in multiple LLCs and things like that for estate planning. And if it was mostly done for that spouse's family, and the legacy of where those assets go is important, does the surviving spouse need to do any different planning to make sure that the intent of what these families' assets were are properly executed? So there's a lot of nuances when you're dealing with a sick spouse, making sure that all of your estate plans are planned for, and should any charitable planning be done to make sure that you're not all of a sudden dealing with a huge tax bracket.
All right. So a question was, what is a QPRT? What is a qualified personal residence trust? That is a vehicle that typically, if a rich person gives away a property and keeps using it, it's included in their estate, and it doesn't work. You can't, the Rockefellers can't give away their beachfront mansion and keep going there. It comes back into their estate. The exception is a qualified personal residence trust. You can give away your home and remain there from a period of 3 to 20 years. And at the end of that term, you have to start paying rent. But it was invented in 1969 in the 1969 Tax Act. It's been around for a long, long time. It's hardwired into the Internal Revenue Code. It's something that's available for wealthier people to transfer personal use assets. I would say that we have a lot of people are looking at Roth conversions. Something you need to know is there is this quirky exception. If you have a pretty significant age difference, I would say more than 5 years, typically it's where it starts making sense. If one spouse has a 401k, and let's say that spouse is 71 and they're getting ready to retire, but they haven't rolled over their 401k yet, and the other spouse is 61, sometimes you can transfer that 401k from one spouse to another through a court order that delays your RMDs for 10 years. And so that is called an in-marriage qualified domestic relations order, a little esoteric. But if you have a large estate and or a large 401k, you have to do this while it's a 401k, not when it's an IRA. But if you have a larger 401k, it's something that you can do. So if there's a bigger age difference between the two, and you want to wrap up with the Quadro's qualified domestic relations order, it's typically in a divorce, but it can be in marriage only with the 401k, not an IRA.
Yeah.
So
but
what do we
in this
got going on
case,
here?
Yeah, in this case, there was a significant age gap. So there was about a 10-year age gap with a surviving spouse, a widow that we have helped consult. And this is just an illustrative analysis of that type of a size IRA. That was a $5 million 401k that then got inherited by the surviving spouse as an IRA. And because there is a 10-year delta before that surviving spouse has to start taking, before she has to start taking required distributions, which will throw her into a super high tax bracket. Taking this year where the market's been down, we can maybe take some losses. We can also still file in that higher tax bracket, that lower threshold, the marginal tax bracket. When you're married filing jointly, the marginal tax bracket is lower. we can analyze, does it make sense to do a Roth conversion? And in this case, this is the type of modeling that we did for a widow, and it adds $15 million in a tax-free bucket over her lifetime by doing this type of planning. So this is just one of the other types of tools that we have when we're consulting with our clients and advising them. We do a lot of advanced planning. We want to know, okay, so what's our tax situation today? I think we can all agree taxes are probably going to go up over time. And this is where we were able to look at, this is the end result. Either we pay a lot of taxes, which these two graphs are not to the same scale, as you can see. This is someone, if you go back to the tax report, if we don't do anything, we're going to be paying, over $750,000 a year in taxes, where we can get that to, closer to 500.
Still a lot.
But that's 250,000 a year for a long time.
Crazy.
So these are the types of planning that we like to do. When you're dealing with, potential widowhood, there's a lot more nuances, and having that A team is important. And so that's why Cunningham Legal and Ascent Wealth Management have our relationship together. And we're happy to do myself or any of our certified financial planners are equipped. We do have a lot of women on our team, and we can help analyze what is most appropriate for you, whether you are looking at potential widowhood or have been widowed or need to do planning as a single female. We also do a lot of planning for women and surviving spouses, men as well.
All right. Subscribe to our YouTube channel. Review us on Google. That'd be very much appreciate that. We'll open up for questions. We'll give you a few minutes. We've kind of reached our 1 hour magic time period. But thank you for joining me, Christina. And if you have any further questions, you can put those in the chat later today when this is on YouTube. Have a great day.
Thanks, everyone.